Senator Benson.
Thank you, Madam President and members. House File 133 is a provision that would allow obligors in the case of spousal support to petition the court for review of spousal support in a situation where cohabitation would be similarly situated to marriage. Such bills have passed in 12 states, including most recently in Massachusetts. The language before you has been worked on by legal aid. It is supported by the family law section of the Minnesota Bar, and the American Academy of Matrimonial Lawyers testified in Judiciary Committee. Some of their suggestions were taken, and upon leaving that committee, they were satisfied with the language and did not speak in opposition to it. Members, a brief walkthrough of the bill. This applies to Section 518 that hasn't had many changes in recent years. And members, we're all aware that cohabitation has become much more accepted societally in the 20 years since this statute was last looked at, and many people are opting for cohabitation in lieu of marriage. Paragraph A, spousal maintenance under this section would be pursuant to the current statute for spousal maintenance. The courts are given great discretion in this case. If you review the language, members, the modification can consist of reduction, suspension, reservation, termination, or no change to maintenance. In determining if there should be a modification, the court has to consider if they would be married were it not for the spousal maintenance award. What is the economic impact of the cohabitation? What's the length of the cohabitation and the likelihood that it would endure? And what is the economic impact if maintenance is modified and cohabitation ends? And again, members, the court cannot modify any agreement that has been stipulated to as part of divorce proceedings. They can only modify court-ordered spousal maintenance. Additionally, this section would not apply to any relationship that cannot be a marriage. That is under Section 517.03. That would be grandparents, children, siblings, etc. You're not allowed to marry, and therefore moving in with your children doesn't trigger this provision in law. Action cannot be taken within 1 year of the decree of dissolution or separation. That gives a cooling off period. And the final section is an effective date, but also added to the effective date is that modifications can only be brought on or after August 1st of 2016, so that any proceeding that is currently in court wouldn't be slowed down by the debate and passage of this bill. And members, I do stand prepared to answer questions, and I ask your support on House File 1333.
Senator Eaton.
Thank you, Madam President. I strongly oppose this bill. The real solution would be to eliminate the law ending that ends the financial support if you marry. If you look at the handout I had delivered, you will see that women have continue to make significantly less than men. And there's a lot of facts and information about how that is true. And especially when the women's role continues to this day as the primary caregiver of elderly parents or children. They miss the opportunities for everything from getting promotions at work to taking to being able to move up in their field, because they often have to turn them down because of those obligations. The point of this bill would be that whether or not a spouse has been unfaithful or not allowed, is not allowed to be a factor in the initial determination of spousal maintenance. Thus, a man could leave his wife to live with another woman, but that would not affect how much he would pay in spousal maintenance. Yet, if his ex-wife subsequently lives with another man, she stands to completely lose her spousal maintenance. And the flip side of this is that the obligor may be living with her sister or mother to reduce her living expenses. But we would allow this because it's not a sexual relationship. What is the underlying motivation behind the bill? I just have to state that many women who I know personally have helped put their husbands through college to become doctors, dentists, whatever, or have built up a small business or a farm with their husband for 18, 20 years, and then the marriage is dissolved, and they get the spousal payments in lieu of the business, instead of breaking up the business, which cutting it in half would destroy it in a lot of cases. So they can then no longer ever have a relationship because then they would lose the money that they invested in that business or that farm or in that career of their spouse. This bill is fundamentally unfair to women, and I would urge your opposition to it.
Senator Benson.
Thank you, Madam President. All this bill tries to do is put people who are similarly situated in a relationship to have the same standing in court. So if a spouse, an obligee, the one receiving spousal support, gets married, they can be taken to court for a modification. However, if they live with someone for 6, 10, 12 years, perhaps have children with them, there is no way to go to court and raise that issue because a marriage does not exist in that case. And Madam President and members, I'm not going to go into a deep dive on statutes, but Minnesota Section 518.552 deals with how spousal maintenance is determined, and then modifications to which this chapter applies talks about if there's a substantial increase or decrease in the gross income of either the obligor or the obligee. So I don't want to get too far afield. This is just to give the opportunity for people who are similarly situated to have equal opportunity and access to the family courts.
Senator Eaton.
Thank you. I just wanted to add that because of the lower income, the lower finances that women have, often, in my experience anyway, the person who is paying the spousal support often has the resources to hire an attorney who's one of the best in their field, while the person receiving the support is usually at an economic disadvantage. And my understanding is you don't get a public defender, so you have to go, in my experience anyway, they've had to go borrow money from their families to hire whatever attorney they could afford, which is generally not on the same caliber as what the person trying to get out of paying the support can hire. This whole thing is, it's all skewed toward the person with the higher income who is paying the spousal support, and the other person who has contributed to the whole process is left without any resources.
Senator Hayden.
Well, thank you, Madam President. I rise to not support this bill. I was thinking about it, and unfortunately I didn't get a chance to sit in the Judiciary Committee and kind of listen to the back and forth, and certainly I'm not a lawyer, but what it does seem to me is that we're setting up a system where somehow there may be some folks out there that have spousal maintenance. They have to pay alimony, and in this case they feel like the person who they're paying it to, and we'll just use a man and a woman for the sake of the argument, the man who is paying now somehow senses that the woman is in this long-term relationship, and that they assume that being in that long-term relationship, that the person that they're in it is now that they're living together and that now their household income is together. So they're making that assumption. Then they have to figure out how much that is, and somehow in this particular situation they're being shorted because they believe that they're paying somebody for spousal maintenance because and that they shouldn't be, or that it should be lowered, or it should be modified because they somehow have figured out that that person doesn't need it anymore. I mean, that's essentially what we're talking about here. And so I have problems with that because, as Senator Eaton has outlined, the power dynamics are often with the person who is paying. That's the reason why they're paying. The second issue is, how do we determine that? How do we figure out what's going on there? It reminds me of the old welfare laws where you would send out a social worker to knock on the door and look under the bed to see if there was a man's shoes, to check the mail, to walk around. Do we hire a private investigator to follow this person around to figure out if they're living with someone? How do we know that the situation that they're in is not a roommate that they're with? How do we know it's not a platonic relationship? Because we assume that when we talk about the family that they moved in, because we've excluded that, as Senator Benson said. So I think that as we start to think about this bill, it does hurt women disproportionately, but it could hurt another man or another woman based on now the way that our laws work for marriage. But in this particular case, I really do think that excuse it. It allows us to now start to put this person in a situation in which they could continue to be brought back to court and have to prove that the relationship that they're in is one that doesn't benefit them financially, and somehow they still need that support. Members, I think we're on dangerous ground here. I think that I'm not a lawyer, and I'm sure that there'll be lawyers that will stand up and tell me how it really works. But it seems to me that you can go to court and make that case yourself. I don't think this is a place in which we should be making that. I am deeply, deeply concerned about the message that we're sending here. I am deeply concerned on how you figure out and what is the ways in which you figure out what the relationship is between that person who is getting spousal maintenance and the person that you assume that they're living with, or that they're with, or that they're in some sort of common law marriage. Members, I just don't think this is a place that we should be, and I would continue to urge members to not vote for this bill.
Senator Benson.
Thank you, Madam President and Senator Hayden. And I apologize, members. There's a letter on your desk from the Office of the Economic Status of Women. I hope that you would not characterize that as a statement either for or against this bill from the Office of the Economic Status of Women. They are clarifying testimony that was given in a House Civil Law Committee, and when I spoke with the director of that office, she is neither supportive nor will she speak against this bill. And so I appreciate Senator Eaton dispersing the information, but it is not specifically in support or opposition for this bill. To Senator Hayden's points, we can't do this both ways. We can't say the bar to entering court is financially very, very high, but that people will do this for trivial reasons. And so some of the concerns that you raised would be the case for child custody, would be a case for many things. There are so many complexities in family law, members, that if we could bring this back to, it is about giving people who are similarly situated access to the courts, so that if an obligor believes that the obligee, that is the person who is paying, and the person believes the person who is receiving is avoiding getting married for purposes of maintaining spousal maintenance, this gives them an opportunity to go and petition the court. We give great discretion to the court members. This isn't railroading anybody. I am not trying to substitute the judgment of the legislature for the judgment of the courts. In fact, we are very clear. The court doesn't have to take up this action. The court can take up this action because of extreme circumstances. And once the court does agree to take this action, they have to consider some very serious provisions. Would the obligee be married if it weren't for the maintenance award? And that's the obligation of the person paying, the obligor, to convince the courts through testimony and presented materials. What is the economic benefit that the recipient derives from the cohabitation. What's the length of the cohabitation? This isn't trivial. We are asking the courts to do something very difficult and serious, but our purpose is so that people who are similarly situated have similar access to the courts. And then, as so many things in family law, we have to trust the judgment of the court and their advisors. And as to the financial expense, that is not a problem that we as the legislature can solve. It is disappointing and difficult. I have family members who have spent tens of thousands of dollars a year arguing over child support and spousal maintenance, but that is not a problem inherent to this bill. That is the nature of our family court system when there is conflict in a marriage or in a relationship.
Senator Pappas.
Thank you, Madam President. I'm very nervous about this bill as well because I think it could have some really unintended consequences, that we don't know the situations that people are in, and there may be assumptions made that there are, equal income abilities, and that just isn't the case statistically, is that even women who are college graduates, they go into fields typically that don't pay as well as men do. I think that also, I think there's a huge issue around privacy here, as Senator Hayden talked about, and how do we know that, a single parent to make ends meet may decide to rent out a room. Is she cohabitating then with the person who's renting her room? If she's renting a room to a female, is there an assumption made that they're in a more romantic relationship then as well? Because legally they could be married. I just think there's too many issues here that we still need to think about and discuss, and too many problems that could arise, and too many privacy issues about this whole, how do we know that somebody would marry the cohabitant? Maybe they've never been asked if they would get married or discussed it with each other. I just don't know how a court would ever determine this. It just seems to me to be way too murky. I just don't think we can vote for this bill today.
Senator Hall.
Thank you, Madam President. I stand in support of this bill. I think society has a lot of people that have nowadays avoided or tried to stay away from marriage. And I think as a government, we have looked at civil marriage, at least, as a real positive thing, actually really spiritual marriage, because anytime two commit to each other, it seems to help out society. So I would message this as a pro-marriage bill. I don't think as a society, if you're co-inhabiting, that we should penalize you. But I don't also think that you should be rewarded from the government. And I see that's what's happening, where they can kind of get away with not paying what they should and kind of get two for the price of one. If you're going to act like you're married, I think the state should treat you like you're married and should look at that. The positive side of marriage, I just did a little quick Google. Whether it's spiritual or civil, that commitment, the positive side is it's cheaper. It's better for your economy. You usually make more money. You have better health insurance. Your children are more stable. Mothers are less stressed. Your children have more opportunities in life. You're more likely to stick out the tough times. There are some negatives. Seems like you'll gain weight. You'll have to have a life of compromise. And as my father used to say, I hesitate, marriage is the first step to divorce. A negative. But I want to tell you, I think this is really a good bill. I think she's thought it through. She's vetted it. Everybody's had a chance to speak on it. There was really no negative to it, and that's why it passed. And now we're here, and I think I want to thank the Senator Benson for a really good bill. So I would vote positive on this.
Senator Gazelka.
Thank you, Madam President. Members, first of all, when Senator Benson approached me about being a co-author of this bill, I thought about it at some length. I've had a number of people on both sides of this issue talk to me about it, some for, some against. But I think when we look at this issue, it's not the same issue as it was a generation ago. When Senator Eaton talked about a wealthy man basically not taking care of a woman that was probably a full-time mom, and she was out in the cold, frankly, I think the judges would look at that very seriously. But most of the divorces I see today are a man and a woman both working and divided for whatever reason, and both of them are struggling to make it. They're both on the edge of poverty because of this. And the one that made a little more money has got to contribute to the one that didn't, or the one that's got full custody if they have, the other one has to help contribute. But it has changed, and yet our laws really have not changed. And so when we look at this, I think, significant, but at the same time maybe modest change, we are simply saying that the court should be able to consider some of these things related to whether that person who is now living with another person in what appears to be a long-term marriage-like relationship is benefiting from that financially, and perhaps they shouldn't get the same benefits that they once got. And we're not saying just the woman, we're saying the man too. This goes either way. And so when we look at it, I just want to remind folks that we are simply allowing the courts authorization to consider some of these other factors. They may come to the same conclusion that we shouldn't change the payments, but they might say we should change the payments. And I think that's the point here. And somebody said, well, these are complicated issues. We shouldn't really, why do we want to open these up? They didn't say it quite that way. But I'm thinking when a judge is between a man and a woman that have divided, they're divorced, it's never not complicated, trying to figure out who should get what and how. And so I think this is a step in the right direction. I think it puts both the man and the woman on equal playing field before a judge. If things change in the future, then the judge should be able to consider those changes.
Senator Eaton.
Thank you. I wanted to point out that I distributed Barbara Batiste's memo here on the hearing in the House, because I wanted to show and some data that women are at a disadvantage. It is a power dynamic that they are at a loss in. It's even worse if you're not white. African American and American Indian women earn 62 cents for every dollar a white male does. And our state's Latino women earn 57 cents to every dollar that a man makes. So it's difficult to get an attorney. It's difficult to be in a position where you have some equality in the court battle.
Senator Thompson.
Thank you, Madam President. Members, I wanted to address a couple of the concerns raised by Senator Hayden and also Senator Pappas. There seems to be some consternation over the fact that judgments would have to be made as to whether someone truly was getting financial assistance and support out of a subsequent relationship. Well, as Senator Gazelka pointed out, family law matters do tend to be rather complicated and do require a discretion within the judicial system. But folks, this is what courts do. Virtually every law that we pass in this chamber, if passed by the other house and signed by the governor so that it becomes law, has some element of ambiguity that may need to be figured out along the way. And so that is really not, I don't think, a legitimate reason not to support Senator Benson's bill, because yes, there may be some fact scenarios that are a little bit difficult to deal with, but that is what courts do. That's why we have triers of fact. And I think it should also not be lost here that we tend to be looking at the individual who may have their support reduced and think that that person is not getting a fair deal. But let's remember that if you're the man or woman writing the checks, you may be not so well off financially yourself, and all of a sudden you find yourself writing checks to a former spouse who may be much better off financially now than you are by virtue of a new relationship. That also carries with it an element of unfairness. So these are the kinds of things that a court would look at in making a determination. Thank you.
Senator Sharon.
Thank you, Madam President. I am a co-author as well on this bill, so I did want to speak to the issue that's in front of us. First of all, as others have said, there are some people that in the decision to terminate their marital relationship simply cannot resolve their conflict and continue to use courts and other measures to continue the conflict. That's some, not all, maybe not even most. But nothing about this bill is going to stop the misuse of the court system in an ongoing struggle or unresolved resentment that occurs as a result of a marriage dissolution. Because marriages that are dissolving for reasons of conflict that they haven't been able to resolve. So I agree with Senator Eaton in this regard, that I think if you really want to solve some of this debate and argument, that you would eliminate the discussion at all about whether or not marriage changes the circumstances under which this spousal maintenance is paid. But that's not the situation, and it's unlikely that we're going to be able to move that forward without some significant discussion. What is in current law is clearly an indication, based on a lot of history, that no longer really applies in our culture about what marriage was about and who was the primary breadwinner and who was not. And under that law, even over the years, there has been acknowledgement that if someone marries, that it changes the terms and the conditions under which spousal payments are made. But because people have found a way to not honor that law, in some circumstances, not all, and sort of skirt around that law and are able to achieve the benefits of joint cohabitation at the expense of the other person who has been honoring the law, I don't think this legislature should support that. I think it's really incumbent on us to honor the spirit of the law that exists about changing what it is we pay in spousal payment if the person marries and improves their economic status. Some of the discussion here is about the economic status of women. I certainly do not disagree with the statements that have been made about the difficulties women have in terms of their earning power or how much they are paid in the workplace as relates to the same work that is provided by men, and we do need to make consistent improvements in that. But we cannot assume in this discussion that the only persons that are harmed are those persons who have the lower economic status in the workplace. Any of us here on this floor or in the House or in this state who have children who are in a divorce situation are paying spousal maintenance and are trying to maintain a living standard for themselves while paying spousal maintenance and barely able to pay their rent or pay for their own living expenses, their car and their gas, much less increase the amount of time that they would like to have with their children. And they can't because they're not able to do that along with maintaining their spousal maintenance level, have the right to go to court and say, hey, the circumstances have changed. And they're bypassing an agreement that we make in the divorce law about marital status by simply not going into the civil process of getting married. And we ask the court to review that to determine whether or not, in fact, that is the case. We give huge discretion to the court in this bill to truly analyze whether or not that's the fact, or whether or not the person taking the other spouse, the former spouse, to court is simply acting out some aggression or negativity, and make a decision that really is fair. And this legislature has to be concerned about fairness for those who are also caught in the position where they have to pay spousal maintenance, have limited income themselves, and barely are able to manage their own expenses, much less have more time with the children that they have that they want to maintain a relationship with. So I think we have to be very careful not to bring an assumption in here that there is one group, only one group, that is having a negative impact by the laws that exist in the current state, and allow for this provision, which allows a court to come in and examine a situation to determine if it's legitimate to make a change in spousal maintenance.
Further discussion on Senator Benson.
Thank you, Madam President. We have had quite a discussion, and I appreciate so many of the concerns that have been raised. There are many wrongs in society, and we can't fix them all in this bill. And family court, as I understand it, can be divisive and hurtful and expensive, but we can't fix that in this bill. What we are hoping to do in this bill is so much of what Senator Sharon raised as a co-author, and I thank her, that people who are avoiding marriage to maintain spousal support could be brought in before a judge. And as Senator Thompson said, we ask the court to make hard decisions all the time. We are not, as a legislature, saying this has to happen, or if someone is living together, we're going to treat it exactly like marriage. We're asking the court to give the obligor, the person paying the support, the opportunity to come in and make their case. And if there are bad actors in the family court system, again, that has been a long-term ongoing problem, and I can't solve that with this bill. But what I can do for those people who are having a difficult time making their spousal maintenance payments and their child support payments and all the other payments that the family court has ordered, to maybe help level the playing field a little bit with this bill. And that's what we're asking, members. And I would ask for your support on this bill. I was pleased today to receive notice from the family law section of the Minnesota Bar that they do support this. And I'm asking for support, members. I think this is a common sense solution, and on its face, if someone has been living together for 6 years, 10 years, if they've gone so far as to change their name, are they living within the spirit of the law, or are they using a technicality to avoid the law? And so I'm asking for a yes vote based on that fairness, Madam President.
Senator Eaton.
Thank you, Madam President. I did have a constituent ask me to ask, what about the situation where the payee would have liked to be the payer from a business and was not awarded the business? And so the unfairness that I want to speak about, though, is that you're terminating spousal maintenance for the obligee if she cohabitates, presumably because her living expenses have been reduced, but not correspondingly increasing spousal maintenance if the obligor cohabitates, thus reducing his expenses and freeing more income for spousal maintenance. It should work both ways.
Further discussion on House File 1333. Senator Latz.
Madam President, I was not going to get involved in the discussion on the floor here, but I have to respond to Senator Eaton because she's conflating two different issues here. The purpose of spousal maintenance is to sustain the standard of living that the recipient of the funding had during the marriage. It's not to increase, since we're using her as the examples here, it's not to increase her standard of living when the husband ends up increasing his later. It's to be able to continue the standard of living that she received while she was married and is now no longer married. So they're two completely different issues. If a husband goes out and gets remarried, or his business takes off or whatever, and he's all of a sudden making a whole lot more money, that has no impact on whether his ex-wife was living any differently now than when she was married to him in the first place. So it's really comparing apples and oranges there. You know, I did a little bit of legal research while we were sitting here on the floor, and I looked up a site called Find Law, which is quite a common site for people, including lawyers, to turn to for basic law on these questions. And it said that even generally and nationally, how long must alimony be paid? It says most awards end if the recipient remarries. So that's sort of the legal standard around the country. And it just makes common sense to me that if someone chooses not to remarry for the purpose solely of perpetuating what is intended to be a temporary spousal maintenance award, because yes, they are temporary, intended to be temporary, until the ex-spouse can get on his or her feet financially, then then we ought to be supporting this bill to give an opportunity to go into court to have a judge review it. And we are not going to solve all the family law issues here. We are not going to solve the economic disparities that we all recognize occur in society for women as compared to men with this bill. But it does give an opportunity for whichever spouse is paying the maintenance to go into court and to ask a court to review some of these very difficult questions. For that, and to do so in a more streamlined fashion with a clear set of guidelines and rules, because it'll be in statute and not with more ambiguous standards contained in case law or nowhere at all.
Further discussion? Senator Herr.
Madam President, I have an amendment to this bill. Amendment C, SH 133A50.
Secretary, report the amendment.
Senator Herr moves to amend House File Number 1333 as follows, page 1 after line 5. And this is the A50 amendment.
Senator Herr.
Madam President and members, I know this bill is quite intense, and it's conflicting depending on your point of view. And it's always important for people to decide on their marriages, and also it's always good to have unity, being as one. But the tribulation of life and the trial of life took us to a different place, and our decision changed, and sometimes we may want to separate, and then we have to, in a civil society like ours, we have to make rules and regulation to manage that, and that's what this bill is about. But my amendment is talk about civil marriage, and is to ask the approval of allowing legislator to officiate marriage, because it's important that we, as a family, to be united, and it's important that we include legislator to officiate conduct marriage. There are many other public officials like judges, retired judge, and court administrators.
Madam President?
Yes.
Point of order, please.
State your point.
Madam President, I'd like to challenge this amendment on Rule 35 of germaneness. This addresses Chapter 517, where Senator Benson's bill addresses Chapter 518A, and also what we're talking about. This is also substantially different than Senator Benson's bill, which just gives legal standing. This infers a new ability of a legislator to perform a duty. I actually don't disagree with Senator Herr's premise. It's just I don't believe this is the right vehicle.
Advice? Senator Herr.
Madam President, I'd like to take on your decision on whether this is germane or not.
I rule that the point is well taken. It's not germane. And further discussion on 1333. Seeing none, the Secretary will give the bill its third reading.
House File Number 1333, a bill for an act relating to civil law, allowing for modification of spousal maintenance based on the cohabitation of the obligee.
Secretary will take the roll. All senators voting that desired to vote, the Secretary will close the roll. There being 45 ayes and 12 nays, the bill is passed and its title agreed to.